वो कोई बात नहीं, but we cannot delay the process. Otherwise, we'll have to extend. No, there's no point. Let us start it in time.
A very good morning to everyone. This is a beautiful Saturday morning, at least here in Delhi, where the weather is very nice today. And we have Mr. Arpit Jain, who's joined us very graciously on this beautiful Saturday morning to share his views on the non-discrimination clause and the nuances of non-discrimination clause in international taxation. And to start off this session, I would invite Mr. Sushil Agarwal, Chairman IFA Northern Region Chapter, to give his opening remarks.
Good morning, friends. Good morning from Sushil Agarwal and from IFA NRC. Friends, we have a very interesting topic for discussion today. Nuances of non-discrimination in international tax laws. Well, Article 24 of the UN model and the OECD model deals with non-discrimination. In order to provide equality in terms of tax treatment, this article provides that the tax provisions cannot be discriminatory merely because one person is a non-resident. A person may be a national of the source country or maybe a national of the country of residence. And there can be a situation where a person is a resident of either of the two states, but is a national of some other state. Or there can be a situation where a person, entity P is there in the source country. In all similar situations, such situations, the clauses relating to non-discrimination arise because there cannot be a tax treatment which is more burdensome on the non-resident when compared to a resident or a national or another PE of some other state. So, well, one very important condition, of course, would be that the circumstances in which these two comparable entities are being evaluated have to be similar in nature. Now, there can be clear exception to this rule when it is a matter of public bodies, non-governmental, non-profit organization, or governmental bodies who are engaged in precisely development or larger good of the source state. Another example would be where the treaty itself has a provision to this effect that the discrimination is part of the DTA itself. Now, the nuances of this law would lie in identifying what constitutes discrimination, the various entities that can claim it, the basis of comparing the circumstances where the discrimination is argued. It also lies in identifying what is burdensome in terms of tax rates, in terms of tax compliances, whether the benefit available to a most favored nation state can be a criteria to claim discrimination and so on. And we need to also enlighten ourselves on the modus operandi of the non-discrimination clause and why the same had been brought itself into the statute as a separate clause. So this is a very crucial and interesting topic under double tax avoidance agreements. And today we have a very fiery speaker in Mr. Arpit Jain from KC Mehta and Company LLP. On behalf of IFA, I welcome Arpit and all the participants to this wonderful treat. As Ishita has already said, it's a wonderful day and we have a good weather outside. So let us enjoy the weather inside also. Before I hand over back to Ishita for further proceedings, let me briefly introduce IFA to you as our audience includes non-members. International Fiscal Association is a leading international NGO on tax matters. Established in 1938, IFA is a neutral and independent platform discussing international tax issues. World over, its members comprise corporates, tax professionals, government officials, jurists, academicians, and so on. Headquartered in Netherlands, it has over 12,000 members worldwide. And if India branch, it was set up in 1983. It has more than 400 elite members and it is expanding. So friends, with this, I hand over back to Ishita and let us take the proceedings forward. Thank you so much.
Thank you, Sushil sir. So I'll introduce Mr. Arpit Jain. Mr. Arpit Jain is a professional having more than 20 years of experience. He is a partner with KC Mehta and Co. and he leads the international tax and transfer pricing practice and also heads the Ahmedabad office of the firm. Mr. Arpit Jain has gathered diverse experience in his past 20 years of working as a professional, where he also worked with Deloitte Haskins and Sells for more about 6 years. He has been named as a leading transfer pricing professional in India by the TP World Report in 2014. And he has also authored the very well acknowledged report or double noun taxation for the International Fiscal Association 2016 carriers. And with Mr. Arpit Jain is also a regular faculty on intensive certificate courses offered by the Institute of Chartered Accountants of India. And now I would invite Mr. Arpit Jain to start his deliberation on the topic.
So, thank you, Ishita, for those kind words. First of all, let me thank IFA, NRC, and Sushilji for providing me this opportunity to share my thoughts on what are the possible opportunities under, I would say, nuances under non-discrimination clause in the tax treaties. And good morning, everyone. I think thank you very much for joining on this Saturday morning. I think Saturday mornings are generally difficult and. But we are going to discuss an interesting topic. This is not going to be dealing with a particular provision, and probably it's not going to be a classroom sort of a thing. I think the idea for today's session is, I think we would be discussing about Article 24. What are those principles that emanate, and where lies the opportunities for us to exploit in that Article 24? In fact, I would rate this as one of the hidden gem which has not been utilized or exploited as much as it could be. Indian jurisprudence on non-discrimination pretty selectively available. There are a couple of items on which it is significantly negative, and there are a couple of items which is significantly positive. But I believe the Indian tax treaties, I think they can significantly come to the rescue for having corporate taxation relief, and I'll discuss this along with some of the case studies and the scenarios that probably could be available. Let me just make a mention here is I think since jurisprudence in India is very limitedly available, I think I'm likely to discuss the pros and cons of what could be the possible scenarios. I might give my view also on a particular matter, not necessarily that appears to be the only view. Especially because non-discrimination is something where it would always have a conflict with the law. And therefore, I think a judicial interpretation, as and when it comes, how a judge would look at it and how would they interpret it, whether it would be literal versus harmonious, objective interpretation, I think we would have to see. What I have tried is I've tried to put my thoughts across, and probably you can explore whatever the remaining aspects of it. I'm not going to deal with all those situations which might be giving rise to non-discrimination. I'm going to lead you with some of the thoughts that I have, which can be probably further explored or developed to identify the circumstances under the Indian Income Tax Act, where probably non-discrimination clause could be exploited. I'll share my screen. Let me know if this is visible.
Yes, it is visible.
Yeah.
Arpit.
Thank you. Okay. All right. So, non-discrimination. Non-discrimination, it is contained in Article 24 of OECD Model Convention. UN Model Convention also have almost an identical Article 24. The primary objective of it is elimination of discrimination in taxation based on certain specific circumstances, and it would require certain specific grounds. All other items, circumstances, activities, or the enterprises, they should remain same. And we will discuss as long as we move forward. There are typically 4 types of discrimination which the model convention prohibits, and broadly I would say the Indian treaties are also modeled based on that, with few exceptions, which also we'll discuss as we go along. So it prohibits discrimination based on nationality. It prohibits discrimination based on, I would say, a residential status, only limited to in case of a permanent establishment. Discrimination based on location of the recipient of income, basically, and discrimination based on the ownership of that enterprise. Why it is important here is I think there are few clauses which not only which does not permit the non-resident to invoke non-discrimination clause, but actually it enables a resident entity to invoke a non-discrimination clause in India, and that gives rise to some of the very finer or nuanced circumstances, which I think shall be discussed as we go along. Start with paragraph 1 second. Okay. To start with, paragraph 1 of non-discrimination, and it says nationals of a contracting state shall not be subjected in other contracting state to any taxation or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirements to which nationals of the other state in the same circumstances, in particular with reference to residence, are or may be subjected. And then it says the provision shall notwithstanding apply to Article 1, notwithstanding the provisions of Article 1 shall also apply to persons who are not residents of one or both the contracting state. So I think there are a few fundamental things that we should be aware. So it applies to nationals of a contracting state, even if they are not resident of the either state. So this is an exception to Article 1. There are hardly any exception. Article 24 is full of some such exceptions, basically, to the basic fundamental understanding of a tax treaty. So this is exception to Article 1. The claim would lie with the country of, so with respect to Article 24, para 1, the claim would lie with the country of which person is not a national. So as an Indian citizen or as an Indian national, I cannot make a claim under para 24(1). It has to be made by a non-national, because it says nationals of a contracting state shall not be subjected in the other contracting state to any taxation, basically. So as an Indian citizen, if I am being regarded as not ordinarily resident under Section 6, if I fulfill some of the conditions, can I say that because non-nationals are not being subjected to same treatment, therefore this is more burdensome? This would not be the coverage of paragraph 1. This can be only invoked by non-nationals. It deals with discrimination either in relation to a taxation or any requirement connected therewith. When we talk about taxation, we are talking about basis of charge, method of assessment, quantum of assessment. And when we're talking about requirement connected therewith, it would include the procedural aspects also, which is connected with the taxation, which could be returns, payments, prescribed timelines, and all those things. Other or more burdensome. So what it requires is, I think you are supposed to provide them an equal treatment and not a favorable treatment. So a non-national can seek an equal treatment, not a further favorable treatment. It's possible that the domestic law itself may be providing for a favorable treatment to a non-national, which is permitted in Article 24, paragraph 1, that does not rule out that sort of a possibility. It doesn't call for equality on all sides. It is only a non-national can seek equality selectively if it is not available, and if it is available to the nationals of the other state. The comparison, with whom the comparison is to be made. It is to be comparison to be made with nationals of the other state. So if there are two jurisdictions, a national of a Germany invoking paragraph 24(1) in India, then the comparison is to be made with the Indian nationals. It is not so if a Belgian national is getting some better treatment in India with respect to the same particular item, maybe by virtue of a tax treaty between India and Belgium, that is not something which is under comparison. So the comparison would always be in the context of how is an Indian national being fared or treated on that particular aspect. If there is any more, if the requirement for a non-national or a national of a Germany is more burdensome, then that treatment can be regarded as a discriminatory. So this is different than a most favored nation, where a German resident would actually look at what sort of a treatment or what sort of a benefit or a relief which is available to any other national or any other national of an OECD country, as we are very commonly looking at it. So this is pretty different from an MFN treatment that one may be looking at from that perspective. This could be a very important element to be kept in mind. In the same circumstances, ideally it signifies that all other circumstances or a material item which leads to that scope and coverage of taxation, except for that nationality, which is the basis of differentiation, that should ideally remain same. So that you actually come to, or it leads us to a conclusion that the differentiation is purely based on nationality and there are no other factors which are impacting that particular item. And this is pretty important. What is important is, I think in particular with respect to residence, this is very explicitly mentioned in OECD and UN Model Convention, the current version. What it says is the nationals, if their residential status is different than the national, so if national who wants to claim a parity with an Indian national, the residential status also should be same. So if the residential status is different, then they cannot be treated as under the same circumstances. And the OECD also very categorically says that this is otherwise implicit in the word in the same circumstances of having a similar residential status or status. So even if it is not specifically mentioned as part of paragraph 24(1), I think this is still to be read that residential status should be the same in order to claim a non-discrimination clause. So when we discuss about 24(1), I think one of the first important thing which comes up is what is the meaning of national, whether it would include only individuals or other legal person. OECD model commentary and number of Indian treaties also, they define national as apart from individual, it also includes legal person, partnership, association deriving its status as such from the laws in force in that contracting state. Natural, apart from natural person, even juridical persons who derive that status of a national, I think that should be covered as part of the definition of national. But there are a number of treaties which also deviate from this. For example, India-US treaty gives this benefit only to individuals and doesn't extend it to non-individuals, basically. India-UK, it does not have a definition of national itself. And in that circumstances, what do you do? So it doesn't have a definition of national itself. There is a Supreme Court ruling in case of a State Trading Corporation of India, wherein it was said that the corporation may have nationality in accordance with the country of its incorporation, basically. So it's a dual relationship, basically, which may arise for the consideration under international law and not under the law, citizenship law, basically. And therefore, it had granted that status that a non-natural person can also be regarded as a national. And so there is a Bombay tribunal ruling in case of Standard Chartered Bank, wherein the UK-based bank, which is where the definition of national doesn't exist, it was treated as an eligible to invoke non-discrimination clause in India-UK tax treaty. So I think very simple rules as to or process that you can follow to determine as to whether a non-discrimination exists. I think you will have to identify first the subject of differentiation as to who wishes to make the claim for non-discrimination, who is someone who is differentiated. Jurisdiction where the differentiation is made, whether it is in the same state where he wants to claim or in a different, depending on the paragraph that you're looking at. What is the basis of differentiation? Like in para 1, we said it was a nationality based on which a differentiation was being made. Then the hypothesized comparison will have to be made as to if all other parameters remain same except, let's say, the nationality, would the answer be different? And in that case, if the answer is different in that case, then this would probably tantamount to a discrimination. Finally, the effect would be you identify if there is a discrimination, identify the coverage, simulate or hypothesize as to what would be the scenario or a result if that differentiation would not have existed, and probably you will have to give effect to that. I'll come to some of the case studies little later on paragraph 1 also, because it has some intricacies with other paragraph. Paragraph 2 deals with stateless person, where it says that any stateless person who are not national of any contracting state, but if they are resident of either of the state, then also they are extended the similar benefit as they are in the paragraph 1. As an India's position, I think this is not much relevant from an India perspective. India has already reserved this as part of OECD commentary also. And except India, Romania, and India Latvia treaty, there are no other Indian treaties which actually includes paragraph 2. This is perimeteria same, except that not nationals, even the stateless persons who are resident of either India or that country can also make that claim. This is the only distinction. Paragraph 3, I think this is much debated and deliberated paragraph or the portion where at least there does exist a decent amount of the jurisprudence. Paragraph 3, it says the taxation on a permanent establishment which an enterprise of a contracting state has in the other contracting state shall not be less favorably levied in the other contracting state than the taxation levied on enterprise of the other state carrying on same activities. This provision shall not be construed as obliging a contracting state to grant to resident of the other contracting state any personal allowance, reliefs, or reduction for tax purpose on account of civil status or family responsibilities. I think to start with, this applies where there is a permanent establishment, and so permanent establishment shall not be taxed in less favorable manner in the other contracting state as compared to the enterprise of that other state carrying on same activities. I think this is perimeteria, primarily the objective. For primary difference, it applies only to taxation. It does not apply to the other connected requirements, basically. So procedural requirements, you may not be able to probably call upon paragraph 24.3. As opposed to 24.1, which talked about taxation or other connected requirements, basically. The comparison is to be made with the enterprise of the other state. So enterprise carried on by a resident of the other state. This is how it is defined in all of our treaties. So an enterprise which is carried on by a resident of the other state. The comparison again is between, let's say, a German company having a PE in India. The comparison would be between a PE of German company and an Indian company carrying on the same or similar activity, basically. Then the comparison has to be based on that. So typically what it germinates is it is discrimination based on this residential status. Someone who is a resident of Germany but having a PE in India. I think that should not be discriminated, or the taxation for that should not be different than an Indian company carrying out same activities. I think OECD model commentary is pretty clear that if there are regulated and unregulated activities, they would not constitute same activities because then they are subjected to very different sort of oversee and regulations. So they are not same activities, and therefore that basis of differentiation would be permitted. If there are NGOs or there are state entities, they are not considered under same circumstances, because then there are public policy related matters which would surely cause differences in their treatment, and therefore they are not treated as a discriminatory. So these are exceptions, not explicitly mentioned in the paragraph, but largely on an understanding basis. I think they are not considered as under the same carrying on the same activities, and therefore they would be excluded. As we said, there are exceptions based on civil status or family responsibilities, which would not be treated as a discrimination. I think let us understand, and probably one of the most deliberated topic on paragraph 24.3. So let's understand through a case study. So A Limited, which is based in Japan, that's engaged in executing a turnkey project in the infrastructure sector. It has got a project in India for which and executing for onshore portion. It has established a project office, which is typically regarded as a permanent establishment in India. The Indian PE is subjected to 43.68% tax because it's a foreign company, 40% plus surcharge and cess. Whereas any Indian company which is executing a turnkey projects, they are taxed at 25.17%, 22% plus surcharge and cess based on 115 BAA. So our question is whether a non-resident or a foreign company, can it invoke non-discrimination clause in India, Japan, DTAA? I think there is good amount of jurisprudence on this. I'll come to that. Let us first understand what are the real underlying things in respect of this. So India Japan DTAA Article 24(2), it says the taxation on a permanent establishment which the enterprise of Japan has in India shall not be less favorably levied in India than the taxation levied on enterprises of India carrying on same activity. Now, simpliciter reading, I think it pretty categorically says that a permanent establishment of a Japanese company cannot be subjected to a taxation which is less favorable as compared to an Indian company carrying out same activity. So Indian company carrying out turnkey activities, it would be subjected to the tax rates, which is 25.17%, and whether therefore levying about 43-44% tax on an Indian PE of a Japanese company, would that be regarded as a discrimination? OECD model commentary, it says the taxation would include assessment, which is quantum of tax. So it should have the same rights to deduct trading expenses, same depreciation rates, including additional depreciation and all, taxation of capital gains and blah. So higher rate of tax to permanent establishment is so OECD considers that would be violative of Article 24.3. In Japan, it was 24.2 because India does not have that stateless persons article. So 24.3, when it refers OECD, it is to the OECD model commentary. And it also says that comparison of rate should be based on a similar legal structure. So OECD is forthcoming that such a differentiation in tax rate would be treated as a discrimination, and therefore which is not permitted under Article 24.3. In an Indian context, 2019 Calcutta High Court ruling in case of Bank of Tokyo Mitsubishi Limited. I think there it was held that the legal fiction envisaged in Article 24.2. This was again an India-Japan treaty. It was that for the purpose of applying appropriate rate, the permanent establishment of the Japanese entity had to be regarded as a domestic entity. So you have to presume that that entity is a domestic entity. That is a sort of a discrimination which can't apply. They will have to read down the law, and therefore it will be taxed as if it is a domestic company. That is the effect of expression taxation not be less favorably levied than the taxation levied on the enterprise of that other contracting carrying on the same activity in Article 24.2. I think what is important is in 2000 through Finance Act 2001, India had introduced an explanation to Section 19 with a retrospective effects of from 1962. And this decision does not discuss or deal with that particular amendment. What does the explanation says? So explanation says that for removal of doubts, it is hereby declared that the charge of tax in respect of a foreign company, charge of tax in respect of a foreign company at a rate higher than the rate at which domestic company is chargeable shall not be regarded as less favorable charge or levy of tax in respect of such foreign company. So the Indian government introduced an explanation which said that, which effectively nullified the, or rather said that charging higher rate of tax to a foreign company would not be regarded as a less favorable charge, and therefore it is not a discrimination within the so as per paragraph 24(3). This is the position for the. Subsequent to that, in fact, we have a CN Bank judgment by Mumbai Tribunal, which was delivered in 2022, and it held that higher rate of tax in case of PE is not violative of Article 24. While coming to that conclusion, in fact, it referred to the Calcutta High Court ruling, wherein it said that because it did not consider the explanation to Section 90, which was introduced with retrospective effect, that judgment is not binding and or per incentive. And the differentiation, it also had one more reason, logic, or basis, which says the differentiation is based on a prescribed arrangement to declare dividend in India and not based on nationality or a residency. And therefore, I think this is not a discrimination. There are justifiable basis for it, and therefore it would not be violative of Article 24. I think the whole question that probably it would lead us to a question is whether an unilateral amendment in Section 90, whether it can override an express non-discrimination provision in a treaty. So most of the Indian treaties, and at least a number of treaties, were signed prior to 2001. So whether introducing an explanation at a later point in time, I would say, whether that can override an express provision in a tax treaty, and there are multiple facets to the whole question, I would say. I think this would emanate or start from the question as to whether do you get an access to a tax treaty from Section 90 or from Article 51C of the Constitution, which requires India to foster and respect any international agreements that it would have entered into. I think we have a Supreme Court ruling which says that while in case of a Jolly Varghese, so it says that while the Constitution requires Indian government to follow all the agreements, international agreements that it would have entered into, I think you still need a municipal law to implement treaty obligations. So in absence of a municipal law, you would not be able to invoke any agreement even against the Indian government, basically. So Section 90, to my understanding, is a municipal law which implements those treaties as far as the Income Tax Act is concerned. So we can't simply rely on Article 51C to say that this is much above Section 90, and therefore any amendment in Section 90 doesn't have an impact, basically. So I think any amendment in Section 90 needs to be read in my view. Article 31 to Vienna Convention, of course, it says that I think you will have to respect the parties who were party to the treaties and how they negotiated, what was the basis on which it was negotiated, and you should respect that. So the amendment which was made in 2001 probably was not available to either of the countries which were subject to negotiation, and therefore should an unilateral amendment be subjected to can be read by interpreting a tax treaty. I think I would have a couple of other elements to it. I think the way amendment has been made, the amendment has been made as an addition of an explanation. Hello. Yes. Ishita, can you just go on mute, please? So the amendment has been made in form of an explanation. would it have a different sort of an impact if it is whether it is added as an explanation versus an explicit override in form of a GAR? So section 90 subsection 2, it gives a clear superiority to the treaty as compared to the income tax act. It doesn't subject it to anything. Of course, subsection 2A makes subsection 2 as subject to subsection 2A, which deals with if there is an implication of GAR, it would act as a treaty override. The point is, such an explicit override is not provided when you add something as part of an explanation. So can you say that explanation is merely an intention or an expectation of India while reading or interpreting a particular thing, and whether the mere indication of intention, whether that would effectively be read while you are making a claim in India. Another perspective to here is whether everything would create an override, or would you see whether that explanation or an override is provided for an anti-avoidance mechanism versus a pure computational mechanism. So something which is anti-avoidance probably might still you will have to read or subject to that, but a computational provision provided in form of an explanation may not necessarily alter or limit the treaty provision. That is one sort of an argument, or one sort of an explanation can be made in this regard, and one may still say that non-discrimination provisions in the treaty may still be invoked despite an explanation added to section 90. I think a similar could be the scenario where there are explanation which is added, which defines maybe text. So a similar argument are being taken. I think we will have to still see as to how the law gets developed. But these are a few my thought process behind this. So I think this was a scenario where we were dealing with a Japanese company having a permanent establishment in India. Let us slightly take a case which is different. Here we have an Indian company which has set up a German subsidiary, and the question is, the German subsidiary, based on the facts of the case, it is considered that they have place of effective management in India. It was a trading entity. It does not have people based out in Germany. And on a factual analysis, let's consider or assume that a poem of the German company is in India. And the question is whether when the poem is in India, the German entity would be regarded as a resident in India. Despite being resident, it would still be treated as a foreign company. For tax purpose, it would still be taxed at 43.68% as compared to 25.17%, which any other resident Indian entity would be paying tax. In this context, let's try to understand as to whether this would make any sort of a difference in that scenario. So India-German treaty, it says taxation of a permanent establishment which an enterprise of Germany has in India shall not be less favorably levied than in that others in India than the taxation levied on enterprise of India carrying on same activities. So I think the whole question is whether it is a German entity's permanent establishment in India. I think when you would have a poem in India, it would surely have when you have a place of effective management in India, it would surely have a place of management in India. And therefore you can say that you also have a PE in India. But the way it works is, I think the taxation of PE, which an enterprise of Germany. Enterprise of Germany is defined under India-German treaty as enterprise carried on by resident of Germany. Now, what happens is, as per India-German treaty Article 4, if because it would be a German resident, plus as under poem, it would also be regarded as an Indian resident. And therefore, as per the tiebreaker, it would tiebreak to India. So for the tax treaty purpose, it would be regarded as an Indian resident because the poem is situated in India. So typically the German entity is a resident of India for treaty purpose, and therefore it is not an enterprise of Germany. So PE, which an enterprise of Germany has in the other state, because it is resident of India. So it would not be regarded as a German entity, but it would not be regarded as a German entity's PE in India. So 24.2 was not relevant. But let's try to look at Article 24.1 of India-Germany Treaty, which effectively says that nationals of Germany shall not be subjected in other contract in India to any taxation or any requirement connected therewith, which is more burdensome than the taxation to which nationals of India in the same circumstances and under the same conditions are or may be subjected. So what it says is a German company cannot be subjected to taxation in India, which an Indian company is subjected to. And this is discrimination based on a nationality. I think we have already seen that legal person can surely claim benefit under Article 24.1. So that is fundamental thing. There is an absence of an explicit reference to residence in the similar circumstances. While OECD model commentary said India-Germany treaty does not make a specific reference to, especially in case their status with regard to residence. Irrespective of that, I think we've already discussed that that the residential status should be same. And in fact, in case where a German company is having a poem in India, it is also regarded as having as resident in India. So a German company is also resident in India. When an Indian company which is resident in India, if you are trying to compare, then there is surely a difference in the tax rate. A German company is taxed at 43%, whereas Indian company is taxed at 25%. Paragraph 20, in fact, paragraph 20 of OECD model commentary. This is giving an example in context of a dividend income, but in my view, I think it equally applies in this scenario, wherein it says that foreign company having a poem would be regarded as which is regarded as resident would be in similar circumstances as that of a locally incorporated entity which is treated as a resident. So typically in that case it would be regarded as in similar circumstances, and therefore anything that is more than or more burdensome, then it would be regarded as violative of Article 24.1. So I think we see a good possibility where a foreign company having a poem in India, I think 24.1 can come to a rescue. 24.3 naturally was not applicable in that particular scenario. But I think we are still struggling with two items of differentiation that was suggested by the decision in case of Shinhan Bank, the Mumbai Tribunal judgment of 2022. So one of the basis is that the differentiation or distinction is based on the prescribed arrangements to declare dividend in India. And there is this is exactly what was provided in Instruction 1982-11/4/2000. One may recall that this is issued just before the amendment which was made in 2001 with regard to the higher rate of tax. So this is in consequence to nullify some of the rulings. Basically, this was issued when it says that the non-resident company, if it distributes dividend in India, it will be treated as a domestic company and will then be subjected to same rate of tax as a resident company declaring and distributing dividends in India. So there is no discrimination based on tax on the basis of residence. The difference in rates of tax provided for a foreign company or a domestic company is actually based on whether you distribute dividend in India or not. So the basis of differentiation is not their residence or the PE have in India, but actually 27 says when it says prescribed arrangements to declare dividend in India. There are three requirements. It says the share register of company for all shareholders shall be regularly maintained at its principal place of business within India in respect of any assessment year from a date not later than the first day of April of such year. The general meeting for passing accounts of the previous year relevant to the assessment year and for declaring any dividends in respect thereof shall take place only in India. The third requirement is the dividends declared, if any, shall be payable only within India to all shareholders. So typically, I think the question that I have is whether these prescribed arrangements are the year specific, and the way they are mentioned, to me it appears that they are particularly year specific. So for the year in which you want to claim or regard yourself as a domestic entity, you just need to fulfill these three requirements, and then in that scenario, basically you would be regarded as a domestic company, and in that case you would still be subjected to the 25.17% tax. Question is, where a foreign company, I'm just to ask a question, if a foreign company is not declaring dividend, does it make any sort of a difference for them, basically? So if someone is not declaring a dividend in a particular year, can they choose to fulfill this requirement, and therefore they can claim status of a domestic company? Very well. Whether in my view that should be possibility and should not be a problem. The question that it leads to us actually is, if it is purely a procedural requirement, even if that company does not declare any dividend, and still it would be regarded as a domestic company, does it actually meet the test of base erosion argument that CBDT is canvassing, that in those cases the dividend would be taxable, and therefore in order to cover those taxes we are effectively taxing the foreign company at a higher rate? This is purely a procedural requirement. It is good enough for that foreign company not to declare any dividend and therefore not being subjected to any additional taxes, and still regard itself as a domestic company. So therefore, I think the most critical argument which is being given for this is that there is a base erosion which happens in this case because the dividends don't get taxed in India. Dividends are not supposed to be. In fact, all this, it says declaring any dividends, if any. So I think it very categorically goes to that root of the case that they are talking about more about a procedure rather than actual base erosion. So in my view, I think it is a disproportional representation. So in fact, in this particular case, if we look at one step further, the dividend which is distributed by so it's A Limited, it's actually a GmbH. So a German company is still fully taxable in India because it is going to be fully received by the Indian entity. Question could be, so it is fully taxable. There is no base erosion which otherwise technically apply in this case. A question to my mind would be whether the taxability is arising on account of residential status of recipient and not the source, which is the distributing entity or the foreign company which we are looking at. So and therefore whether that would be a sufficient basis for me to say that there is no base erosion. My point would continue to be that is this so this is leading us to a point that whether the basis of differentiation, pure procedural aspect, and so the basis of differentiation and the consequences thereof, basis of differentiation is pure procedural aspect, which has almost like 50% higher tax. Is it proportional? Because I think one of the very fundamental principle of non-discrimination says that if there is any differentiation, the consequences has to be proportional. It can't be disproportional, or so the differentiation is actually made a very artificial differentiation, which is not having a material impact, and therefore ideally that differentiation is to be ignored in my view. So I think I would tend to believe that differentiation which was argued or which was given in that Shinhai Bank's judgment, I don't think that differentiation really permits Indian tax authorities to levy tax at higher rate in case where the foreign company has a POEM in India. Basis Article 24(1), we are not dealing in Article 24(3) when there is a POEM in India. So that is one of the fundamental differentiation here. I think another argument which leads us to that conclusion is, can the basis of taxability in the hands of recipient itself when we are talking about see, the base erosion argument itself is on that the recipient would not be paying tax on that so-called dividend item, and therefore we want this. Question is whether the taxability in the hands of recipient, can that itself become a justification for differentiation to payer. I think that in that case, special bench case decision in total while, I think there are a few observations which can certainly come to rescue to argue this. Sorry. So I think going again slightly strengthening this case. Let us assume that the turnover of A GmbH. I think I'm wrongly mentioned A Limited here. It's A GmbH. Let's say turnover is 100 crore, and in that case, for a domestic company, when the turnover up to 400 crore is taxed at 25% and above that at 30%. In case of other than domestic company, all companies are taxed at 40% plus surcharge and cess, of course. I think the question is basis of granting lower rate of 25%. I think is it dividend arrangement or size of the company or both? So the question is when I'm comparing with 25% plus surcharge and cess, maybe it might make it 27, 28% somewhere. But then vis-a-vis that to 43%. What is that basis of differentiation? Is it the size or is it being a domestic company or probably both? The question is, I think in this set of a differentiation, it doesn't go into a base erosion. It is purely based on the size of the entity. And therefore, I think this also creates a significant justification that the differentiation is simply arbitrary and not on the rational basis as it's sought to be applied. Could be a very good argument to claim that. So I think this all further leads to a question. I think we answered one point that it is based on a domestic company based on prescribed arrangements. But then what happens to explanation to section 90? So explanation to section 90, I think if I read it again, that was also made in context of Article 24(3). What it says is charge of tax in respect of a foreign company at a rate higher than the rate at which domestic company is chargeable shall not be regarded as less favorable charge or levy of tax in respect of such foreign company. Now this is exact. So it is deeming that this type of a change or a difference will not be regarded as less favorable charge, which is so it is deeming that it will not be deemed as less favorable charge, which is exactly the language which is used in paragraph 24(3). In fact, the circular which was issued, that also actually was trying to differentiate that we are not differentiating based on a residential status. So which was dealing with paragraph 24(3). Paragraph 24(1), which we are right now dealing in respect of a company having POEM in India, it says nationals of Germany shall not be subjected in India to any taxation which is more burdensome. So it is not talking about a less favorable charge. It is purely anything which is more burdensome. So because explanation to section 90 is all about I would say favorable charge, less favorable charge. I think there is a distinction which can be done. My view, I think it's a good arguable case that even explanation to section 90, even if it is stated that should be read while reading a treaty, I think while reading Article 24(1), probably that should not have an implication, or it can be argued that this is not to be read when we are reading Article 24(1). And in fact, that circular probably fortifies this position. As in fact, if we just extrapolate that scenario a bit further, in fact, 115 BAB for a domestic company which prescribes the rate of 15%. Question could still be whether it is a domestic company and therefore whether the differentiation does exist. But it talks about a domestic company. In my view, I think there it should be possible. Company which is incorporated after April 2020, and if it has set up or registered after October 19 and has commenced manufacturing production on or before March 2024, it requires manufacturing operation. So probably theoretically an argument, just putting it across for a thought process. Generally, a foreign company doesn't set up a manufacturing operation through a permanent establishment, and therefore this might actually remain an academic in question. But then, is there an academic possibility that someone is able to claim a benefit at 15% plus surcharge and cess instead of paying tax at 43%, despite being a foreign company? A question. I'm not saying that this is something which, but I'm only putting across different arguments just to strengthen one scenario, that does it lead to a discrimination based on some rational basis or a proportional basis, or is it an artificial uh, condition which is regarded just to differentiate, but it does not have a real implication. So I think in my view, for a case having a poem, I think it would be a very good possibility to argue on 24(1). Case study 3. So I think going back to the permanent establishment a scenario, let's take case instead of a Japan. Let's say what happens if a Portuguese company has a PE in India, and Article 24(2), which is dealing with the permanent establishment. It is exactly same what we had read as far as Japan was concerned. But then there is a protocol to India-Portugal Treaty, which says the provisions of paragraph 2 shall not be construed as preventing India from charging the profits of PE, which the Portuguese company has in India, at the rate of tax, which is higher than the imposed on profits of similar company. So this is making it very explicit. So it will not prohibit India from charging higher rate of tax, higher than the imposed on the profits of similar company in India, subject to the difference between the two rates not being more than 10%. Now, this is an explicit provision which is made in India-Portugal Treaty. If I have to read explanation, to section 90 as to effectively countering all the treaties that are signed by India, and therefore it overrides everything. What sort of meaning that we would be able to ascribe to this protocol, which is signed between India and Portugal, when it says that the difference cannot be more than 10%? Typically, can someone argue that the Portuguese company's PE cannot be taxed at more than 35%? Let me tell you there. So there are some other jurisdictions where also a similar clause applies. In few cases it is 10%. In few cases it is 15%. I think South Africa is another where such a provision does exist. There are a couple of them basically. So I believe this is also something which can be resorted to in case of a permanent establishment situation. Even if someone comes to a conclusion that explanation has to be read fully, I believe well, there is an explicit provision. It can surely protect for any difference which is beyond something which has been agreed. Let me tell you that originally when the differentiation was agreed, that was based on the dividend tax withholding basically. But when it was 30% and 40%, I think the differentiation broadly remained within that limits in most cases. Now that basic rate of tax has gone below to 22%, I think that differentiation could become useful in those cases. Some more jurisprudence on paragraph 3. Whether profit-linked incentives which are available only to Indian company or a person resident in India, whether it is violative of Article 24. I think we currently have a judgment which is a special Ahmedabad special bench ruling in case of Rajiv Suresh Gajwani. In fact, I'll say this is non-discrimination. How does one get into it? See, honestly, this is a case which was argued by us. A question. There was a US resident person who had a proprietorship entity in India, which was doing the software services. And the question, the SSE had claimed Section 80 HHE benefit. During the course of assessment, when he was asked to justify his claim for being a non-resident, in fact, the chartered accountant approached us and said that this is what I have already issued a certificate. How do we get out of it? Because now clearly reading Section 80 HHE, I'm aware of the fact that this is something which can't be claimed. honestly speaking, at the relevant point in time, if you read that judgment, at the relevant point in time, the SSC was also eligible to claim Section 10B. I think a natural question came to us as to why did you not claim 10B? But he said that this is already done. Now how do we defend? And this was the genesis when we created the argument for claiming ATHHE as part of non-discrimination. Went right up to special bank, because there was already a ruling by Pune Tribunal which was negative, and this was after considering that the special bench held that profit link incentive should be available to the non-resident entities. And I would also say that even OECD makes a very explicit reference that any incentives which are available to a resident entity should be available to non-resident entities also, provided they are fulfilling all the conditions which are prescribed for that. So this is an interesting ruling on those lines. Just based on those lines, I think I would ask you to ponder upon whether Section 80IA benefit, which is available only to company which is resident, not which is resident, which is registered in India. So whether the nationality, this would go into slightly different, but whether nationality-based non-discrimination clause can be invoked for a foreign company having an eligible project in India. Now, anyways, ATIA is something which is of past. But then, if you are dealing with some sort of a project in some sort of a litigation in that, can you innovate an argument that whether ATIA can be claimed by a foreign company in this context, invoking Article 24(1)? Paragraph 3, I think we have a couple of other things, but I think let's first move on to other paragraph, and then probably we'll come to a few more case studies if time permits. Paragraph 4. Paragraph 4, it says, except where the provisions of paragraph 1 of Article 9, paragraph 6 of Article 11, paragraph 12(4) apply, interest, royalties, and other disbursement paid by an enterprise of a contracting state. Paid by an enterprise of a contracting state to a resident of other contracting state shall, for the purpose of determining taxable profits of such enterprise, be deductible under the same condition as if they had been paid to resident of the first mentioned state. I think this is very important, and paragraph 4 I think is very useful. See, largely we believe that treaties are generally to be invoked by a non-resident, by generally, so they are useful to a multinational. But I believe this is, see, it says that it is providing a relief or a benefit to an Indian resident for computing its own Indian taxable income. So an Indian company or an Indian firm or an LLP would be able to claim benefit of paragraph 24(4) in their Indian tax return. So they are making use of a treaty, an Indian resident making use of an Indian treaty for claiming a relief in India. Why am making this? So a standalone Indian company, not part of any multinational groups, if they are making payment to an overseas entity for any sort of an expenditure, I think that is something which would get covered here. And therefore, this is very important. So it is not for non-residents. So those applicable only for those who are working for non-residents. This is purely can be claimed by an Indian company. And I think this would give rise to multiple scenarios which could be useful. What it seeks is a parity for deductibility of disbursement. So if you are making a payment to any non-resident, you will apply same conditions as if they are paid to a resident. And if there are conditions which are more exonerate or there are additional requirements, then they have to be ignored. They would be deductible as if they were payable to a resident. The only exception which is made here and which is very explicit here in paragraph 4 also, so any transaction which are not at arm's length. So I think all those para references which appear here, they are with respect to the transaction which are not at arm's length. So if transactions which are not at arm's length, so to that extent, subject to that, I think all other payments would be deductible under the same scenario. That's what paragraph 24(4) says. Let's simply take one example. So A Limited again. So I think A Limited having a PE in India, which a company based in Japan. HO has actually allocated general admin HO expenses worth about 3 crores, whereas if you work out as per section 44C, this would work out to 1 crore. So the question is whether 1 crore is deductible, or Japanese company can claim non-discrimination, invoke non-discrimination article to say that all 3 crores should be deductible for them. 44C, I think it says notwithstanding anything to the contrary contained in 28 to 43A, in case of an SSE being a non-resident, no allowance shall be made in the nature of HO expenses as in excess of amount computed as 5% of adjusted total income. So I think it very clearly lays down that only in respect of a non-resident, this limitation applies of section 44C. And so article 24(2), it says, so when you compare with resident enterprises, I think this is clearly a discrimination or a distinction which is being made. If it is an Indian enterprise, they would be all the expenditure that it would have incurred, it will be deductible under section 37. So and 44C is placing a limitation only in case of a non-resident, basically. So this should be amounting to a discrimination. And this was also already held under article 24(2), which is OECD paragraph 3, basically. So Matchem Canada Inc. versus Deputy CIT. This is again a 2006 old judgment, and I think this is consistently being followed. I think there is pretty much jurisprudence on this which is already available. What is I think so. So 44C sort of a limitation which applies only to a non-resident. I think that can be overcome through invoking non-discrimination article. I think what I would also want to emphasize here is limitation under section 44C or a similar scenario. I think you should, when you are dealing with permanent establishment, I think you can also have a look at article 7(3) itself, and you may not actually need to resort to non-discrimination clause. So for example, in case of a Dalma Energy LLC, which again was argued by us only. So where based on the reading of article 7(3) itself, it was held that 7(3) permits deduction of all the expenses, including HO expenses, and therefore without referring to the limitation placed by section 44C, they should be fully allowed. So I think you may not always need to resort to article 24(2) for claiming a deduction or for computing your permanent establishment. I think article 7(3) at times gives you pretty better tools to deal with. I think we have already seen in case of the special bench ruling for I think BNP Paribas, where certain sort the income were not taxable under the act, and the expenses were actually claimed as a deductible in the treaty, and both the side was permitted, of course, which led to an amendment in section 9 itself. But that only applies to banking company. What about others? Is I think article 7(3) could also be equally useful as a non-discrimination article. I think same example. Let's take a case under India-Germany scenario. So it says the same thing, but it adds that, and according to the so whether okay, I'll say shall. In determination of profits over PE, there shall be allowed as deduction expenses which are incurred for the purpose of business of PE, including executive and general administrative expenses, whether in the state of PE or otherwise, and according to the domestic law of contracting state in which PE is situated. So India-Germany Treaty, Article 7(3), it actually refers and places a limitation, or I would say in accordance with the Indian laws, basically. And Article 24(2) also provides for non-discrimination exactly on same lines, but also provides an exception to what is provided, not being in conflict with provisions of paragraph 3 or Article 7, basically. So I think there it says that limitation of HO expenses, which is provided under domestic law, that would continue. PI is little different and slightly interesting. Korea Article 7(3), it doesn't place any sort of Article 7.3 itself mentions in accordance with the provisions and subject to the limitations of tax laws of India. So Article 7.3 itself says that HO expenses will be subjected to limitation of Section 44C, to read it. But Article 24.2 does not provide for an exception to for the limitation provided in Article 7.3. The question would be, in case of a Korea, whether you can still invoke Article 24.2, ignoring Article 7.3, which explicitly provides about limitation. I think my view would be, I think when Article 7.2 itself provides that it will be subjected to limitation, I believe we will have to read it harmoniously, and so that express limitation is effectively a permitted form of discrimination. That is how I would tend to read, and therefore in that case probably Article 24.2 may not come to rescue for overcoming the limitation from Section 44C. I think there are numerous judgments which deals with a similar scenario when you are making payment without deducting tax at source, whether they would be covered by Article 24.4. And I think there are numerous judgments starting from Herbalife, and I think there are a number of judgments subsequent where it says that Section 40A1, which requires 100% disallowance, is violative of Article 24.4, because if the same payments are made to a resident, and if without TDS itself, if they are allowed, then 40A1 would have to be read down to that extent. Incidentally, subsequently 40A1A has been introduced, where originally there were few items of expenditure which were subjected to disallowance under 40A1A. And that list has been now extended. In fact, the scope of TDS to resident itself has been extended now even to goods also. One possible. In fact, most of the payments that now any large entity would be making, they would effectively cover under TDS. But one of the fundamental difference still remains. Is 40A1 requires 100% disallowance, whereas 40A1A requires only 30% disallowance. So following these judgments, in fact, any payment which you would have made without TDS to a non-resident would also be subject to only 30% disallowance. In fact, if there are payments which are made, which had you made to a resident entity would not be subjected to TDS. In that case, 40A1A would have no role to play, and in that case, 100% of the expenditure can be fully claimed, even if it is paid to a non-resident without doing TDS, because a similar payment was not requiring TDS when it is made to a resident entity, basically. So this is something which is more or less good amount of jurisprudence available. But I think this could be the basis on which you can probably figure out what all other cases where you can seek such protection under non-discrimination article. I think one food for thought. Can you invoke this for disallowance under Section 40A1B, which leads to disallowance because you do not have deducted equalization levy? So I think this is something which you can explore, and probably look at the judgments on 40A1, and probably that could be useful to develop an argument for that. Case study 5. I'll just. So I think on this, this is a case study on Section 94B. How much time do I have? Okay, 15 minutes. So case study 5. A Japanese company having a permanent establishment in India, and it makes payment to a Singapore entity, which is again an associated enterprise. The question that is being raised is the amount of interest is more than 30% of their profit, and therefore whether it would be subjected to Section 94B. So whether can you claim a relief under non-discrimination clause for this sort of a payment? I think one interesting element to start is Article 24.2 India-Japan Treaty. It says the taxation on a PE of Japanese entity shall not be less favorably levied in India than the Indian company. But Section 94.1, when we look at it, so 94B, it actually starts notwithstanding anything contained in this act, where an Indian company or a PE of a foreign company being the borrower. So it doesn't differentiate a PE of a foreign company vis-a-vis an Indian company when you are making a payment. So I think it is not discriminatory. It does not discriminate deductibility based on the status of the payer. In fact, it puts Indian company as well as PE of a foreign company on the same parlance. So it applies to both. So 24(2), which deals with a payer perspective, basically, that is not applicable. Let's look at 24(3), which is the paragraph 4 of similar to paragraph 4 of OECD model convention that we just looked at, which says that except where provisions of Article 9 applies, interest paid by enterprise of contracting state to a resident of other contracting state shall be deductible under same condition as if they had been paid to resident of the first mentioned contracting state. So I think in this case, the differentiation that sought to be avoided is based on who is the recipient, basically. So in this case, a Singapore entity is the recipient, and so if that causes a differentiation, I think that should be avoided. But before we read that, the fundamental question, because I think more relevant treaty from this article purpose would be India-Singapore treaty, because the payment is to a resident of Singapore, AAPT Limited, and therefore whether question would be so the treaty to be invoked is going to be India-Singapore tax treaty. The larger question is going to be whether an Indian PE can access India-Singapore tax treaty. I think that is going to be the larger question, and for that let's first answer a different question. Then we come to that question. Would it make difference if the interest was paid by an Indian wholly owned subsidiary instead of a PE of a Japanese company? Instead of a PE, if it was an Indian company, would that answer be different? So in fact, so section in my view, if it is paid by an Indian company to a Singapore company, which is an associated enterprise, Section 94B does not deal with recharacterization of that into an equity. It simply says that if your interest expense is more than 1 crore, then interest is deductible only up to 30% of your EBITDA. Basically, it is deferring the interest deduction. The genesis of this was thin capitalization, but the way Section 94B is worded as far as Indian Income Tax Act is concerned, that equity ratio is irrelevant. So they are not aiming to identify an entity which is thinly capitalized. They simply follow a threshold of 30% of EBITDA, and that is how it is to be disallowed, basically. So in fact, OECD model commentary also at para 74, it says that if interest is that the amount of interest that you pay is at an arm's length, then thin cap rules they are violative of Article 24(4). So you can very well apply Article 24(4) of OECD to claim that those thin cap rules are not applicable, and therefore full amount of interest is deductible. So I think 94B, I think non-discrimination clause should surely apply if it is an Indian company. But I think we revert back to the question whether a PE of a Japanese entity would be able to claim an India-Singapore tax treaty. My answer to this would be, if an Indian WOS can claim it, why not a PE? In fact, India-Japan DTAA exactly prescribes that same treatment, because it says taxation of PE of a Japanese entity in India shall not be less favorably levied than the taxation of Indian entity carrying on same activities, basically. So I think in my view, this of course run contrary to Article 1, or I would say as an exception to Article 1, not contrary to Article 1. But if you are the genesis of non-discrimination is that Indian entity doing same activity and PE doing same activity should not be differentiated, then I believe this is something which would surely lead to the conclusion that a permanent establishment should be able to claim India tax treaty also. And as far as Article 1 is concerned, I would believe that Article 24(2) is trying to hypothesize PE as an enterprise of that contracting state, basically. And if PE in this country is actually taxed, PE in this country is taxed on a worldwide sources, then this could not be actually in conflicting with Article 1 in my view. So if you are also taxing that PE's foreign sources or something else, I think this should be a good proposition. There is a ruling in case of European Court of Justice. There are ruling which is in context of EC treaty that basically this would be violative of non-discrimination clause, and a permanent establishment should have an access to a tax treaty despite the fact that it is non-resident in that particular jurisdiction. OECD model commentary also, it confirms third country treaty access to PE for grant of foreign tax credit. So I think these are few arguments that can be developed further for taking the benefit. So I think what I would take as a takeaway is in this case 94B in my view is surely non-discrimination article can be invoked, and can be full direction can be claimed in respect of that, because that is the distribution based on the pay status of the pay recipient rather. And I think PE can also have access to a tax treaty in respect of their foreign sources. Basically, I think this is something which I would say. Paragraph 5, non-discrimination. Okay, paragraph 5. So paragraph 5 eliminates paragraph Article 24, paragraph 5. It eliminates any discrimination based on ownership. So enterprise of a contracting state, the capital of which is wholly or partly owned or controlled directly or indirectly by one or more residents of the other contracting state, shall not be subjected in the first mentioned state to any taxation or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirements to which other similar enterprise of the first mentioned state may be subjected. I think a few quick points. I think we are short of time, so important is this benefit is available to Indian resident entities and not the owners who could be outside India for you to claim benefit in India. It eliminates discrimination based on the foreign ownership, wholly or partly. So question could be whether multiple DTAA access could be there in case of a numerous investor, directly or indirectly. Again, intermediate or ultimate holding companies residential status could be used to invoke this possibility. I'm just posing some questions which probably you can ponder upon at a later point in time. I think it is dealing with taxation of Indian company at parity regardless who owns it. So dividend withholding taxation of owners is not something which is covered here. I think case study 6 probably I'll skip. I just mentioned there is a ruling in case of a Pune tribunal ruling in case of a Daimler Chrysler India Private Limited, wherein section 79. So section 79 doesn't permit carry forward of losses if the shareholding has changed by more than 51% for a company which is not a company in which public is substantially interested. This was a company which was a subsidiary of a company which was listed in Germany. So had it been a subsidiary of a listed Indian company, then it would have been treated as a company in which public is substantially interested. And in that case, section 79 would have no application in that. So Pune Tribunal in this case said that merely because the listed entity was incorporated in Germany and listed in Germany, I think that is precisely the differentiation based on Article 24(5), which is the ownership-based differentiation or discrimination, which has to be read down, and therefore Daimler Chrysler was allowed the carry forward of losses based on this ruling. This is a case study. I think I would probably take 5 minutes on this. Let's okay. There is an AB Private Limited, which is a joint venture. 67% is held by ASPA, which is an Italy-based company, and B Limited, which is an India-based company. They are into designer mosaics in India. and B Limited, so AB Limited, AB Private Limited that manufactures them and supplies it to either A or B Limited. As far as Indian JV partner is concerned, B Limited, they purchase it and trade and sells it across India. The Italian partner is concerned, they purchase it from AB Private Limited and then they distribute or sells across the rest of the world. The price that AB Private Limited charges to both of them is decided. They are standard price, which is exactly same price at which they are charging. During the course of transfer pricing, TPO decides that the profits are not sufficient, or they actually incurred losses. The profits were not sufficient, and therefore TPO decides to make an adjustment. He says that because 75% of the sales were made to Italian company, and therefore 75% of that differential profit is proposed to be adjusted as part of transfer pricing adjustment. The question is whether AB Private Limited can claim non-discrimination clause benefit to avoid transfer pricing adjustment. I think what is most critical in this case is let's assume that a mosaic is charged at $100 to the Italian company. It is charging same $100 or equivalent INR to be limited for supplying same sort of mosaics. The question is so the transfer pricing adjustment, which is currently being proposed only in respect of transactions which are with the Italian company, is it merely because that company owns 67% in AB Private Limited, and therefore can you say that if it is an undercharging of a sale price and similar adjustment doesn't arise in case of transaction with B Limited, should transaction with A Limited also not be subjected to a similar treatment that is there in respect of a B Limited? And believe me, this is not a hypothetical case. This is actually a case which was argued in Ahmedabad Tribunal. So unfortunately, on some other grounds, there was a relief which was granted. It did not give ruling on non-discrimination, so they left that issue open. But this is something which was already argued. My view, I'll just give my view pretty much open. I would say I think someone read on Article 24(5) non-discrimination. I think IFA Carriers 2008, written by the stalwart Rahul Mitraji. So I think he find in that I think on the transfer pricing adjustment on the income side, it should be possible to argue and develop a case that this ownership-based non-discrimination is that clause can be invoked, and probably you can seek some relief under that. Now, I would just put a caveat here. I think few years back, again in IFA, I had occasion to meet him when I asked him whether are there any developments on that particular front, and he's in fact in that case he had said that he appears to be reconciled to the view that this should not be possible, despite the fact that I would still believe that this is much open an issue as of now. And one should try and develop argument on this line. We never know what sort of an outcome that it could give. Very honestly, when I look at non-discrimination, I think I would look at it scenario. So is it adjustment because Italian company owns some share in this company, or is it because of transaction with it? What would have happened if my transaction was with another AE of that Italian company? Because in that case, the condition would not have been fulfilled. And therefore, whether the ownership is causing this adjustment or whether the transaction is causing the adjustment, I think that differentiation will have to be made out. From this perspective, if we look at it, I think it looks like the 24(5) or may not be available for transfer pricing adjustment. But slightly tweaking this into a different thing is per se a question could be whether transfer pricing provisions they can be subjected to non-discrimination clause. And assuming that 24(5) fulfill the requirement of where it should get into, this is a larger question that transfer pricing provision per se whether it can be subjected to non-discrimination clause. So whether Article 9, which effectively enables TP adjustment, whether they are in conflict with Article 24(5) or not. My view in that is Article 9 only enables transfer pricing adjustment. One cannot say because it permits it, it doesn't mean that because it does not specifically provide for a domestic to domestic transaction transfer pricing adjustment. Because I think when the agreement treaties were drafted, I think they had no occasion to mandate how a domestic transaction would be treated. But they can surely mandate as to there should not be a discrimination between those treatments. So I would believe. So even Article 24(5), if the way it has been worded and most OECD model commentary as well as all the Indian treaties, it does not provide an explicit exception to ALP adjustment like what we discuss in Article 24(4). Reasons could be multiple. I'm not saying, but these are possible things that can be developed in an argument to argue this. OECD's position is pretty clear. I think they say that transfer pricing adjustments are not violative of Article 24(5). I think OECD's position is pretty clear on this. But I think if someone wants to develop something, I think so there are European Court of Justice couple of judgments which I've just mentioned, Stace Clements and Lancost. I think post this judgment, there are a number of EU countries which introduced domestic transfer pricing legislation. In fact, UK adopted domestic transfer pricing legislation, but they wanted to give relaxation to SMEs, and therefore they exempted SMEs from domestic transfer pricing legislation. Let us assume that anyone with up to 5 million pounds transaction worth of that, and they were exempted. As an extension, because just to not find as this is a discriminatory, in UK they even granted an exemption to the international transactions where the transactions are with country or related party which is based on jurisdiction with which UK has DTAA with a non-discrimination clause. So UK has literally, effectively, they have understood that this discriminates if they don't have a domestic related party transaction subject to transfer pricing adjustment. The international transaction would be treated as a discriminatory, and therefore they actually extended the benefit to all those treaties having a non-discrimination clause suo motu, and this is as part of their regulation. So I think their UK's position appears to be very clear that this would be effectively treated as a discrimination. I think Ajay sir has already joined, and I am yet to finish few things, but I think we can probably I'll leave few thoughts, and then if time permits, we'll connect.
Thank you, Arpit, for your excellent exposition on the subject, and for going into the subject or taking us into a deep dive on the issue of non-discrimination clauses. I would now welcome Mr. Ajay Vora, Senior Advocate, and Mr. Mukesh Bhutani, Chairman IPA India, to this panel, and would ask them for their comments on this very important issue of discussion today. Good morning, sir. Good morning, sir.
Morning, Ajay. You want to go first? It's around, or you want me to go?
Ajay sir, you are mute, sir.
Yeah, I think Mukesh wanted me to go first, so I'll just point out, and I must confess that whatever little I know of non-discrimination is thanks to Mukesh when I argued the Herbalife judgment in the Delhi High Court. But Arpit, I must compliment you for this excellent and comprehensive presentation. I had never, gone through the non-discrimination article in different treaties that you've done in so much detail. And there are nuances with respect to each treaty. And this non-discrimination article is one where you don't have substantial jurisprudence. It is left much to interpretation. And you have done well to point out the various issues that arise. Of course, this is not an article which is frequently pressed into service, but this can be used in points of time to really get into a question whether there is an issue relating to non-discrimination. I joined towards the end when I heard your last exposition on the transfer pricing. Unfortunately, we lost in the Delhi tribunal, where they said that when you make this comparison, you are making a comparison of a resident entering into a TP transaction or an international transaction with an AE. So since the TP provisions equally apply to a resident, in similar circumstances, it will apply to a non-resident carrying out a related party transaction or an international transaction with an AE. So on that basis, I think it was paragraph 5 of that particular article where it dealt with nationals of a contracting state. And the question was, it includes a corporation. So there were many nuances around it, whether nationals will include a corporation and whether in that situation you could be said they are similarly situated. And hence the TP provisions, if they are applicable to a resident, we said between two residents, TP provision don't apply. So the tribunal came back and said you have to compare a resident in a transaction with an AE vis-a-vis a non-resident in a similar transaction with an AE. So that's the similarity that they drew, and they did not accept this contention on applicability of the non-discrimination article qua an international transaction entered by a non-resident. So I think I will say that I don't have much knowledge on the subject, but I've gone through your presentation in detail. If there are any issues that we'd like to discuss, I'll be happy to contribute.
Thank you, Ajay. I think you're being extremely modest, but yes, this was a very interesting case. And I had to ask first, before we actually High Court, Ajay, that this is a fit case to argue. Ajay was referring to a Herbalife case, which is actually the first High Court case on non-discrimination. Interestingly, Arpit, as you correctly pointed out, we were dealing with Article 24(4) of the India-US Double Tax Treaty, and the question was whether the Income Tax Act 40AI is discriminative Article 24(4) was on amendment have not been withheld. Interestingly, if you look at the history of Article 40AI, it has carried out some, strange amendments over the year. As you know, 40A as a disallowance has been evolving in nature. So the domestic law was first amended to provide disallowance for non-residents only. And then the domestic law was amended to bring the residents on par with non-residents from a disallowance. I think argument that was advanced by Ajay to the Delhi High Court was that, look, nothing can be more discriminative than what it appears like. So there are, there was, I remember, intervening 3 years in which Article 40AI apply only to non-residents. And Delhi High Court was convinced that this is clearly non-discriminative, but only for those 3 years. I think it was a very interesting case, and subsequently, the Delhi High Court also followed this in the case of Mitsubishi Corporation India Private Limited in the context of India-Japan Treaty. So thank you very much for pointing it out.
So
There are
Mukesh,
13 of...
Mukesh, just one point. Mitsubishi has been referred, I think, to a larger bench in the context of, transaction relating to purchase of raw material. The argument that was raised was that since the provisions of section 194C do not apply to a sale of raw material, and therefore the non-discrimination article will apply, I think the Delhi High Court has referred this to a larger bench and it continues to be pending. I think we've lost Mukesh. So while Mukesh is rejoining, Arpit, I also saw your slide which says that today disallowance under 40IA is restricted to 30% of the expense, right?
Right.
Now the question is that there is also this circular of the board which says that the disallowance under 40AI with respect to payment to non-residents is to be restricted to the tax payable on the transaction. So how do you reconcile or between these two positions? One, that under 40I, the disallowance is limited to the tax payable on the transaction, and the 30% under 40IA. So when you invoke the non-discrimination, what is it that you are seeking to use today?
So I would say, sir, I think whichever is I think there were, in fact, in the past, as Mukesh sir also mentioned, that there were a plethora of amendments that were carried out, even on procedural aspect. when one was expecting to deposit the TDS or be, within the due dates under the quarterly payments, whereas for residents this was permitted right up to the filing of return. So even all those things were also actually treated as burdensome, and therefore those relaxations were provided as they were available to the resident. So in fact, I think the CN Bank judgment, which is Mumbai Tribunal, that effectively expands everything right up to, so anything which is in 40A1A, I think that so effectively applies to 40A1. So that sort of a relaxation is, I think that would be my thought process.
Yeah. So interesting. The Delhi High Court still continues to hold the ground on the entire law relating to non-discrimination. But I think we have to understand that if you look at the history of non-discrimination, let's look at it. Where did it arise from? Actually, it arose from Article 14 of the Convention for Protection of Human Rights and Fundamental Freedom, and on the grounds of sex, race, or color. And the first landmark quote that came was from the European court, where in this famous case called Walker versus the United Kingdom state. And it actually put down a very simple definition of what is discrimination, again, in the context of human rights. It says a difference in treatment is discriminatory if it has no objective and reasonable justification, or it does not have a legitimate aim, or there is no reasonable relationship of proportionality between the means employed and the aim sought to be realized. Which means that even under Article 4 of the Human Rights and Fundamental Freedom Convention, the word non-discrimination is subject to many caveats. Interestingly, it is also, or coincidentally, it's of the Indian Constitution, which talks.
There seems to be a problem while Mukesh sir is joining. Ajay, would you please continue the discussion?
Yeah, I think Mukesh was dealing with the background behind insertion of this non-discrimination article, and he referred to Article 14.
He's joined back in.
Okay.
I don't think the courts in India have dealt to these forms of discrimination. I think hopefully when these matters go to the Supreme Court, it will be done. But as I look at double tax treaty, whether you look at the OECD Model Convention, UN Model Convention, or the US Model Convention, essentially discrimination or application of Article 24.4, which has about 5 or 6 limbs, depending on which model you're. The first discrimination is national. Second is the stateless based. Third is PE related discrimination. Fourth is expense related. Fifth is ownership related. And sometimes there are taxes covered related as well. In India, all the cases, as you saw, there may be other cases as well, but most of them fall in the category of expense related. The Delhi High Court judgment on Herbalife was on expense related or disallowance of expense. And the other common cases in it, actually, I wonder why the non-discrimination argument did not feature high on the recently decided special bench decision in the case of Total, which was dealing with dividend distribution tax, Ajay, which I'm sure you would have been eating, sleeping, breathing for many, many months. And I think that this is a argument that needs to be pushed in order to take the course to its logical conclusion as to why should there be a discrimination over here? It's not discrimination when it comes to levy. The dividend distribution tax is levied on residents and non-residents alike, but it's discrimination vis-a-vis the treaty. I'd just like to kind of summarize it by saying that when you talk about discrimination in the context of Article 24, you need to be looking at this very important phraseology which is used in Article 24, which says treatment less favorable. Now, when you talk about treatment less favorable, it becomes more a subjective principle rather than a set of objective criteria. These objective criteria are either laid down by way of technical explanation in the treaty, which really brings the treaty partners together. As we all know that besides none of the treaty India has any technical explanation. In fact, courts have gone ahead in India and held why the technical explanation under India-US treaty will apply, or the principle of res judicata will apply for other treaties as well. We've seen this very popularly in the context of make available clause under the India-US treaty. So, but if you look at the India-US treaty, there is very little spoken about on the non-discrimination side.
Okay, so there's a slight lag in your internet. I would just suggest that you turn the video off, so it might be the bandwidth would improve.
Mention, or you need to look into the OECD commentary. But this phraseology less favorable is important. Arpit, you made a point on whether application of Chapter 10 transfer pricing law is non-discriminatory. My personal view is that you cannot invoke non-discrimination. The reason being, non-discrimination or less favorable treatment is always subject to domestic law legislation on anti-avoidance. So if a country has transfer pricing law, it's a stated public policy that the country wants to, avoid tax evasion, and hence it has a comprehensive law, and hence a transfer pricing law will not invite the invocation of less favorable treatment, because a transfer pricing law is to curb tax avoidance. Of course, there can be situations where one country has a comprehensive transfer pricing law, or pricing law than the other contributed enterprises of those countries. There could be situations of non-discrimination that could come in those situations. But to say that transfer pricing per se in today's environment will give the taxpayer right to invoke non-discrimination may not be the correct reading. I was also a little bit intrigued when I was doing my research that how many treaties does India have which does not have a non-discrimination? Are the three treaties. I can merely attribute some logical reasoning. Oman and Saudi Arabia, given the fact that they are not true democracies, and they would have specific constitutional framework which would not allow non-discrimination clauses to be invoked by their citizens. They carry the same message in the double tax treaty. Greece is a very interesting example, but an outlier situation, because India-Greece treaty is amongst the oldest treaties, and possibly the treaty negotiators in the 60s, I think the Greece treaties in the 60s, could not have thought of non-discrimination, because the entire human rights debate on non-discrimination came much later. So that's really my overall comment. But Arpit, I'd like to also join Ajay to congratulate you for a well-researched paper, which I'm sure will help not just this set of participants, but others as well, to get into this subject in a detailed manner. Thank you, Arpit, and
Thank you.
and maybe we can, let people ask questions and direct them to Arpit, who's the subject matter expert. Over to you, Ishita.
Yeah. So Mr. Jain, there's some questions. One was on Herbalife that's been answered. So there's a question by Mr. Atisha Jain. It says some treaties include higher rate of 40% and limitation to exposure such as 44C is not discriminatory. Is there a way around it?
So I think if the TT explicitly contains a limitation of HO expenses which is subject to section 44C, I don't think then there is a way around. That means it is an explicit intention of both the parties to honor those 44C limitation. I don't think then either Article 7.3 or non-discrimination, either of them should come to a rescue. I think as far as higher rate of tax, I think that's a controversy. I think which has already been discussed, and there are a number of judicial precedents. I believe there are few things which have not been probably. I still believe that it can be argued that on the principle of proportionality, the basis of differentiation and its consequences are pretty different. The judgment which Mukesh sir mentioned, it also relied as to what is a justifiable differentiation. I think that's where it might fall. And so in case of a higher rate, my gut feeling, I think we still have a chance to argue it. Of course, it has to be on similar basis. By and large, we have already had all decisions which are more or less in case of a banking companies, when naturally there were situations which were regulated, unregulated, plus there were government mandated requirements, and therefore I would believe whether they are in similar situations, probably there were judgments which said no. But I think in other cases, I believe there could be good cases to still argue that higher rate of tax for a foreign company should not apply. And I have given my reasons for that in the presentation.
Thank you. Then there's a question from Mr. Dwarkesh Sridharan. What about section 94B? Will protection under this clause be applicable?
My view is yes.
Mr. Atisha Jain has asked another question. India-Ireland Treaty provides that a higher rate of tax is not discriminatory given the protocol itself. I think so it's not much of a question, it's a statement. So we'll move on. Ms. Vandana Sagar has asked if there are any views on the discrimination embedded in section 2013 of the Income Tax Act.
201. So I think we'll have to. The question is. So honestly, I'm not examining it from that perspective. Might need some time, honestly.
If I may ask a question, Ajay sir, Mukesh sir, thank you for your comments. They were very insightful. I have a question specifically towards both of you and Mr. Jain as well. There's a lot of cases by the ICSID on where they interpret the non-discrimination clause in terms of investment law and international investment law and international investment treaties. So how much can we rely on those interpretations to interpret the non-discrimination clauses in our DTAs?
If you are referring to the bilateral investment treaties, probably they stand on a different footing. So far as the double tax treaty is concerned, we will really be governed by the specific language of the non-discrimination article. This is a country by country negotiated settlement or a negotiated document. So we will have to necessarily look at the specific terminology provided in that given article to determine whether or not it's a case of non-discrimination. So frankly, if you see, and I was enlightened by Arpit's presentation, in fact, across different treaties, there are minor tweaks and minor variations in the language of Article 24. And that makes all the difference to how the particular article will actually play out in practice. On 44C, I think I was a little intrigued. I had never thought that this could also be subject to the non-discrimination article. But Arpit has pointed out some case laws on that issue. I would think the question that comes to my mind on 44C is the conflict between Article 7.3, if it provides that the expenses will be deducted as per domestic law, versus Article 24, which will have primacy, whether it be Article 7 or it will be Article 24. So I think those are open questions. Then on 94B, I was also going through his illustration, where it's a situation where a loan is taken from a Singapore entity and the P is from a different country, and his question was whether you can access the India-Singapore Treaty. Again, my personal view is, if you are looking at the deductibility in the hands of the payer, I don't think you may need to look at the India-Singapore Treaty to invoke the non-discrimination article in that treaty. So I think these are open questions. You may not have a ready solution. And again, jurisprudence will only evolve in this field. I don't think the tribunal is the final word on it. These matters may be litigated further. They may be taken up to the highest court. And we will have some views and authoritative pronouncements only once the Supreme Court is to decide on particular shades of the non-discrimination article in a particular treaty. And whatever they decide for one treaty may not equally hold good for another treaty if there is a difference in terminology. So to answer your point, I think to come back to that question, the non-discrimination article in a treaty is more specific versus the wider language of a bilateral investment treaty, which is actually to promote investment. And Mukesh, I'm sure, has piloted many such conflicts which have reached international courts. And Mukesh can throw better light on your particular question.
Thanks, Ajay. So I just wanted to make sure, Ishita, I follow your question. Your question is that can a non-discriminatory treatment for tax purposes open up a window for invoking non-discrimination, for invoking bilateral investment treaty? If that's your question, I don't have an answer to that, but bear in mind that invocation of a bilateral investment treaty for tax purposes has a very high bar. Ordinarily, a bilateral investment treaty is not invoked for tax purposes. If you just look at the Vodafone and the Kane Hague Tribunal Awards as an example, what was invoked was fair and equitable standards under the bilateral investment treaty. So the question was, and of course, in the Kane arbitration, they also invoked the expropriation clause under the bilateral investment treaty, which the Hague Tribunal did not go into because the Hague Tribunal decided both the cases on the fair and equitable standards. Your question could be very theoretical. Can a Article 24 non-discrimination clause under the DTAA be invoked under bilateral investment treaty? I would say I have my doubt. And when I'm saying this, I'm mindful of the fact that theoretically the answer could be yes, but practically it would be very difficult to say that a non-discriminative treatment is leading to a shareholder or an investor rights getting impacted in the state in which the investment is made. Because I just point out one principle in the Hague and the Vodafone case, in the Kane and the Vodafone case. In the Kane award, the Hague Tribunal extensively dealt with what is a investment-related tax claim versus a tax claim. And it says what they are dealing with is the investment-related tax claim. As a result of amendment to the law, how the rights of an investor were impacted, and hence they intervened in that. So sum and substance of it is that the standards for invoking a BIPA or a BITS is very, very high. And I have my doubts whether a non-discrimination clause for tax purposes can be taken up under BIPA.
Thank you, sir. Thank you, sir. Thank you, Mukesh, sir, for your views. I would just invite the audience, if they have any more questions, they can raise their hands.
So, Ishita, I just want to make one comment. I think Mukesh sir did mention about chapter 10 and non-discrimination. So, sir, I fully agree with what you said. I'm just probably trying to make one sort of an understanding which probably I carry, and you can correct. I think there is in large number of cases the differentiation. So a differentiation, whether it is justifiable or not. If it is not, then it will be treated as a non-discrimination basically. A differentiation, and in large number of cases, differentiation is justified or argued that there is a base erosion, and therefore this differentiation is justified in case when I treat with a resident or in case when I deal with a non-resident basically. My concept is slightly different in that I think I would differentiate between two. Is base erosion is something which is base erosion versus avoidance. If something falls within avoidance, I think it is surely it would not be treated as a discriminatory because it is aimed to and whereas base erosion is something which I would believe that when someone agreed to a particular treatment. So all the articles of a treaty except for Article 24, I believe that this is only a principle-centric article which only lays down principle, does not lay down a situation as opposed to all other articles. And therefore, I think it would certainly put itself onto a higher pedestal as compared to the other article or any transactional things which are prescribed under the domestic law. It is based on a principle, something like GAR, which effectively overrides any transaction. So you go beyond what is stated in an explicit provision of law. I'm not saying that transfer pricing, whether it falls into base erosion category or whether it is into an anti-avoidance. Naturally, Chapter 10, as it has been specified, it is anti-avoidance. So it's like free trade agreement. They or even this for Section 90, they say that they can grant relief from tax, which is chargeable under the Act, to promote mutual trade, to provide a parity treatment, basically, whether you are in India or outside India. Free trade agreements, when they agree on a 0% customs duty, it is effectively to provide a common market to them. Something similar to this. So I am providing you a similar treatment. I don't look at as to whether I get tax or someone else. Again, a very raw thought, but this is what I'm trying to just pick up and develop. Not necessarily that this is right, but I thought I'll just share.
Thank you, Mr. Jen.
I think, Arpit, you are right. But the point is that you must come within the strict language of that non-discrimination article.
Of course, sir.
I think the article has to be very strictly construed to understand whether you satisfy the parameters of a particular provision of that article in order that you can claim non-discrimination and therefore the benefit.
Fully agree, sir. Fully agree.
We have Ms. Vandana Sagar has actually elaborated her query with respect to 201, and it is actually very interesting. So what she's asked, the example she's given is that under Section 201, an order can be for the limitation for passing an order against a resident is only up to 7 years. But in case of a non-resident, there's no time limit. So I think so. What she's asking is, can that be treated as a discriminatory?
So I think I've just read. So I think this is okay. Fundamentally, the order under Section 201 is passed in respect of an Indian resident company, for example, when they made payment to either a resident or to a non-resident. In case of resident, there is a time limit which is prescribed. In case of a non-resident, time limit is not prescribed. But who is the subject matter of that differentiation is subject matter is an Indian company, and therefore for that subject matter there are only two provisions which are relevant: paragraph 4 and paragraph 5. Paragraph 4 strictly speaks about deductibility of an expenditure. It doesn't talk about whether proceedings can take place there or not. And paragraph 24(5), it talks about the ownership-based differentiation. So Indian company can only invoke only those two items, basically. So in my view, 201 may not fit into that sort of feature.
Ishita, I would not take Vandana to non-discrimination. I would rather take her to court. So, and assist her in the court. So today the law is that, like as Arpit said, 7 years for payment to a resident. There is no time limit for the 201 to be passed in respect of payment to a non-resident. And the courts have said you have to read a reasonable time. And the judgments of the courts are largely that it is 4 years from the date on which tax was deductible. So she does not even have to go to 7 years. She can press the Delhi High Court judgment, the Bombay High Court judgments, which have taken, of course, the matter is pending in the Supreme Court. That she should say that beyond 4 years, they cannot take any action with respect to payments to non-residents. So if she goes the non-discrimination way, it will get extended to 7 years. She should claim a more favorable treatment for payment to a non-resident, which is the present law.
Thank you for this excellent advice. On a very light note, I'm saying this. Thank you for this excellent legal advice without an invoice following to it. And I especially made a note of it. So I would now call, I would thank all the panelists, and I would now call Mr. Smita Patni to give the vote of thanks.
What an enlightening session on a bright Saturday morning to end with. I profusely thank the speaker of the day, Arpit ji, for taking us to the such an in-depth discussion on non-discrimination laws with interesting case studies. And my sincere thanks to the stalwarts, Ajay sir and Mukesh sir, for providing their valuable inputs during the session. Couldn't have asked for more. Thank you again for all of you, and have a great day. Thank you. Thank you so much.
Thank you very much, sir.
I think we can close for the day.
Very enlightening. Thank you.
Thank you, sir. Thank you so much, sir.
Thank you, everyone.
Thank you.
Thank you.